Lordship, in regards to item 3, I'm paying for an adjournment.
Item number
3. I'm paying for an adjournment on behalf of Mr. Datta.
paying for adjournment.
Yes, Lordship. He is out of station for some
Who?
reason.
S. Dotto.
Yes, Datta.
S. Dotto means,
Sudipto Datta.
okay. Mr. Ghosh.
Yes, Lordship.
B. Ghosh.
No, AK Ghosh.
Okay, good. Yes,
Maybe
you are for
your
the
lordship.
respondent.
No, my lord.
Okay, Mr. A.K. Ghosh, Learned Counsel. On behalf of, has made a prayer on behalf of Mr. S. Dotto. Has made a prayer for adjournment on behalf of Mr. S. Dotto, Learned Counsel for accused appellants. Full stop. Any?
They
Yeah.
should inform us.
हाँ.
Society.
Legal aid counsel. There is legal aid counsel also. Is there or no? You have informed?
No, Lordship.
Okay, Miss B. Punya, Learned State Senior Counsel and Additional Public Prosecutor for the respondent state, has submitted that state has no into the prayer. Has sought for release the case after 2 weeks on a date 2 weeks by the office.
May I plead your lordship? Lordship, I am praying for IA, my lord, for listing. Delay of condemnation for 5 days.
Give it to the court master for suspension of sentence.
My lord.
Suspension of sentence.
No, no, my lord. The matrimonial appeal matters.
Give it to the court master.
And I beg to mention for listing a Met appeal for order.
Okay, give it to the court master.
Daily list for orders. Item number 1.
Learned, there is no representation on behalf of the appellant to the on-call. Full stop. As per office note. Dated 20/01/2026. No affidavit. In deference to the order dated 5/1/2026 has been received by the AST. Full stop. In view of non-representation on behalf of the petition appellant to the on-call, let the case be listed after 3 weeks. On a date 2 weeks by the office.
Item 2.
May I please your lordship, my lord?
Oh,
I mean, this IA is for my lord condemnation of delay of only 48 days. Notice has been issued earlier.
does the affidavit?
Yes, my lord. Actually, my lord, very surprisingly, on the last occasion, there was a date before family court, not a family court. And along with the client, I myself went to the court because the client is a little bit illiterate. So there, my lord, before the principal judge family court, I made a prayer to serve a copy upon him, upon the lady. And before the court, she denied. That is the facts, my lord, in presence of me before the principal judge now. Now, another aspect, my lord, so far as the speed post is concerned, it is shown, my lord, insufficient address. So those address is similar to the address given before the landed family court, my lord. Now, my lord, on February 3, there is a date fixed before the family court, my lord, regarding payment. So, my lord, those dates may be given to verify the same.
So what steps you want to take? Speed post returned
That is quite.
with insufficient address, remark. Secondly, no dossier affidavit has been submitted. Whatever, this way or that way.
This is the, my lord, the judgment of the copy in my hand, certified copy of judgment passed by the landed family. The address is same.
We are, Mr. Counsel,
My lord.
we are with regard to service of notice.
Yes, definitely. My lord.
Neither affidavit nor served notice has come. Insufficient address, you have to inquire,
My lord.
not for the court to inquire.
Well, the short date may be given because February 3, 3rd February, there is a date before the landed family court. In between, my lord, I'll try, my lord, to verify the same.
Mr.
It's lost score, my lord.
A.S. Loskar, Learned Counsel for the petitioner, is present, has submitted that he may be granted 2 weeks' time to make further efforts to serve the notice upon the respondent by way of Dusty, and also to take first steps for service of notice upon the respondent by speed post at her correct and proper address. The press are allowed, release the case after 4 weeks.
May I pray for a fixed date because there is date before the
The
learned family
case
court.
also.
Possibly.
Into.
এটা দুটা লৈ লওঁ মই এইটো কৰিব পৰা নাই না যদি আছে এইটো ৰেডি কৰি আছো যদি হয় এইখিনিলে পৰিশোধ কৰিছো
For hearing,
এইখিনি কৰি দিম
item 4,
পল্লৱী সুদৰ্শন কিমানখিনি আগবাঢ়িছে এইটো চেঞ্জ কৰিব লাগিব
Lordship, in this matter, item 4, Lordship,
Amicus,
new amicus.
নতুন লিষ্ট Miss A. Begum, Learned Additional Public Prosecutor, has submitted that in view of elevation of the previous Micah Curie for appellant. To events, comma, a new an amicus curiae has to be appointed afresh to represent the case of the appellant. Close to office notes. Also, the respondent number 2 has already been served with the notice. Your principal. Also. However, none has appeared till date to represent the respondent number 2 as well. Postal. In view of the above, we deem it proper to appoint. Ms. Visita Sharma, learned counsel from the panel of Micah Curie, to represent the case, to represent the appellant, and that's one or 2 did you?
What? It. Oh my.
Mr. Edward, learned counsel for the Micah counsel, to represent the respondent number 2 in this appeal. Full stop. The registry to inform Ms. Sharma and Mr. Dhar accordingly, and shall supply a copy of the paper book each to Ms. Sharma and Mr. Dhar within a week from today. The names of Ms. Sharma and Ms. Dhar, learned Micah Curie, appointed today, are to be reflected in the cause list appropriately. Lays the case after 3 weeks. Could you also make
Lordship, item number 5, I am there, Lordship, but this will go through B Bhuyan, Lordship. Now, I am there, let him start. He'll be-
Yes. Conviction is under
302, my lord.
302.
Rigorous imprisonment for life. Fine of rupees
Provisional
5,000.
judgment.
Page 38.
38. Convict.
Accused appellant is the husband of the deceased. And the son is
Husband of the disease.
husband of the deceased and
So,
the informant
injury
is the
side.
son, elder son.
Okay. Or is the FIR?
FIR page 1 starts from 1 and relevant page is 4 and 5.
Hmm. 4.
Yes.
So son has lost the FIR.
Yes. Elder son.
Okay. Where is the charge sheet?
Charge sheet. My lord, page 6.
Charge sheet, sir.
Sorry, charge sheet. Page 72 to 75.
1 minute.
Nine prosecution with
1 minute. Sir, you said 71,
72.
2. Where are the seizure list?
Lordship will find seizure list first, 57 to 58 and 59,
57,
57,
57,
57,
50.
57. These are,
Only one?
no, my lord, there is another seizure list. This seizure list pertains to when the accused,
We are marking it only.
yes,
We are marking it only.
there is 59 is the
So
second.
that-
seizure.
59. So. Andhra Pradesh. Ah, Where is it? 313?
313. 28,
Clear denial.
all denied,
False case.
false case. Truth. 28, man. Page 28.
Hmm. Case map.
Sketch map, your lordship will find Page 64.
A. Yes.
Take your lordship to the first prosecution witness, that is the informant, son of the accused.
Son, informant. PW1,
PW1,
son.
son.
Hmm. This child you are examining? No.
No.
These material exhibits were sent for FSL?
No,
Gamusa,
not,
sari.
not even the Dao.
Who is PW2?
PW Haren Sharma,
Neighbor or
neighbor, in whose house he was
Uh,
watching TV.
informant? Who is, oh, this PWD is same, watching TV.
Yes.
Who is PW4?
PW4 neighbor. Kaubura.
Huh?
Kaubura.
Oh, Gambura.
Page 15. Kaubura.
Oh, PW5,
PW5 is
co-villager.
co-villager. The scissor will. Video. No.
PW seven IO.
PW7 IO.
So appellant confirmed his appearance before the police station by cross-examination of the IO.
The only thing is that it was the IO
Where is the doctor?
doctor is the next PW8. The IO says when he surrendered, there was other persons also.
But three persons he confirmed.
Yes.
And
Correct.
their testimony also said they were in the PW1, PW3, PW5. They also stated in their evidence that they went to the police station.
Police station. Along with the son, informant.
PW1 is the son.
Yes.
On inside wound, the neck. Wound or anti-mortem. Who is next of the? Who is PW9?
PW9 is the second IO. OC
Already completed. Investigation already completed.
completed. I find the only discrepancy between the
So, so the body was inside the house. Admittedly, it was inside the house. PW1 was a son who lived in a nearby house. There was another son who was not present at the time of occurrence. And informant had 2 children. So some that is possible. Inconsistency, girl, one PW3 or
One boy,
PW5 said
one
girl,
girl.
later on he
Yes,
said
these are
that
the-
is possible. But PW1, he clearly said the boy. I think boy and like both of them or one.
No, but two
Ah.
sons.
Huh?
2 sons. They
Both are
came running.
sons. Both are
Page 9,
sons.
yes, page 9, they came running and informed me.
So it would be definitely that not omission, not to mention 2, may not be relevant.
Man, it will be very vital.
But secondly, PW1 said he saw the accused appellant going out. Right. Then he appeared in the police station.
Along with those informant and other persons, the witnesses.
No, that is not the.
Yes, that is what I was just
Where
trying to
is that?
point out. Page 21. Page 21, the line, 7th line from the below.
7 line from?
Below. When the accused,
7 line from top, you read.
yes,
Later, I went to Bihali police station.
yes,
When I arrived at the police station, a person by the name of Gulab Gwala came.
came.
He appeared in the police station with a dove and a stick of betel nut tree in hand. Gulab Gwala said this part is not said that he came after killing his wife. That part is not admissible. I seized the dove and stick made of betel nut, right? And from bottom.
Yes,
When the accused surrendered at the police station, then Babul Gwala, Sosin Rajbansi and Montu Bora were present. They are PW1, 3 and 5.
yes.
Now let us see PW1.
And during cross also,
Now we'll come to that PW1. They were present.
it is not clear whether
Ah.
they,
They were present. Come to page 9.
yes,
Meanwhile, my father had surrendered.
yes,
Right. Then PW3. I think Sosin.
Sachi.
Sosin also said, I went to the police station. He said,
And he said he saw the
he
accused
said,
inside the lockup.
he was taken. We also went to the police station. In the police station, I saw the accused. So it is not indicating that they were together. Had gone together. I saw. Then in PW5, Montu Baraik. I
Along with 4 or 5
accused
persons.
Gulab Gwala cut his wife and thereafter he went to the police station. I along with 4 or 5 other persons of our village went to the police station. The police personnel showed us one dove. So it is not indicative that they went together. You would have said so. Yes, what point you want to show in
Page
the
22.
cross-examination of the IO?
Page 22. Cross of the page, the
Mhm.
second last line.
Present. So, and this one. See the timing. PW1 says 3:30. Actually, it is 3:30. Then it is about 6-7 kilometers. He immediately went there to lodge the
FI.
FIR. Then IO came to the PO 4:40
Four-
PM. Right. Now turn to the in seizure. Turn to the first seizure or second seizure. 59
59.
at 5 PM.
5 feet.
Place of seizure, Kuloguri Gaon.
That is from place of occurrence.
Place of occurrence. And this sari was taken out by one PW at the instruction of the IO. And see, then he said, IO said, he recorded statements of 3 witnesses,
Yes.
right? Then he came to the police station.
At 6.
He arrived at PO 4:40, right? 6 PM, right? He arrived at the police station.
6
Now see
5,
the second seizure, page 57,
6:10.
6:10. So timing was not
Timing was in a
in
very
a
first track.
fast track.
He
but-
arrived police
But
station. at
consistent
5.
with the
That's true.
evidence of the PWs. And because he said PW1, he said he went to the police station. And according to his guess, it is 3:30. And at 4, he was informed at Horen Sharma's house. So otherwise, timing-wise, it is
Timing was
going in
not-
a seamless manner.
It was
And his-
first track investigation.
Fast track could be. Sometimes it is to be appreciated. Right. Now, body was inside. So it demands an explanation from the accused also. Right. He simply said falsity.
Also.
Subsequent conduct of appearance. Otherwise, it would not have been. But these two together, then evidence of quarrel, right? And by way of cross-examination, you could not discredit that you did not contest that you did not appear in the police station. You did not appear in the police station with a dao and one
It was not.
lathi. That was not contested.
Yes.
Not a single cross-examination on this point.
The only thing is that confessional statement which the IO says.
Oh, that part I am saying already, that cannot be taken into account.
Yes, that
That I am not, I have already said, that line shall not be taken into account. But leaving that,
the
if you
circumstances.
see dispassionately, then it owed an explanation.
Correct.
And when it is, he says that after not cross-examining the prosecution witnesses, even the IO, right? He owes an explanation because otherwise it is not a case that other than you, there was somebody else. It is not your case.
Even in 313, he could have said, I have not
He
said.
should have. And if not giving, what is the judgment? All case giving an explanation. Not giving an explanation is another incriminating circumstances against them.
We want remove Maruti.
No, not
Not
remove it.
remove.
There was another constitution kind of judgment.
Yes.
Moi refer করছিল আবার। So that even after that Sarda bhai, Sarda
Sarda.
before Sarda,
Shared BDs and Sardas prior to that.
just head or just Sarda to আমার percent. I know.
Shared BDs and.
Though it is not a case of direct evidence. Looks like You have failed to make out a case by preponderance of probability also.
Yes. That is there.
There is history of quarrel,
The son says,
and you did not say. You elicited
question.
that.
no question was
No, no,
put.
you elicited, you extracted out of them, perhaps. And you have extracted out of this IO. See, IO is PW7.
7.
You extracted, the Dow and stick were seized in their presence, right? All this you have extracted.
And the other thing is that at the place of occurrence, there were 100 to 150 persons present. That aspect, I don't know why this was not been dealt.
And they would definitely gather at
Only 3-4 witnesses from the 100, 150 witnesses.
it is 134 Evidence Act.
Mhm.
Single witness can.
Can do.
There are 3, 4, 5, and everything is in sequence.
But there is
Even the testimony of the person who took out the sari,
Mm.
even that was, he was like,
the child witnesses,
he admitted.
they were not been examined.
So what is the fatality?
They were the only eyewitnesses. Yes, sir.
We don't know whether they were the
They,
eyewitnesses
because
or
they
not.
came running and informed that my father had killed their grandmother.
Ah,
So they were the vital witnesses who have seen the incident.
so whether that has affected the prosecution.
That
That was not whether that has affected in any manner. Had they been examined, they would have, at least the elder one would have taken the line of his father. He would have been declared. And it is lying on the floor inside the house.
just
And you two, appellant and the wife, plus the younger son.
the son doesn't also say that while his father was running, he was carrying those da and lathi. Nothing.
He let him go, he said. He admitted. So that could be a fair, truthful one.
No, that he was.
He
with
saw,
the-
I let him go. Whether to catch his father or to save his mother.
obviously safe.
For a reasonable man, it would be the second
Same.
option.
Second option.
To save his mother. He said also, letting my father go, I came home and saw that. So that is an act of a reasonable person, which demands from a reasonable person. Rationally.
Correct.
Doesn't it? Doesn't it?
I think it's 60.
Yeah. Edition is right. And owed an explanation. It was in explanation. 106 right? Arun, not giving an explanation. Because it was circumstances to hitting text. Maybe the probable one. Truthful one. Mention falsity. And when his wife died inside the house, in his own house, he owed an explanation, at least some explanation. I was not there.
Yes. At least
At least that. False case. That is not an explanation.
The only consideration is the age of the,
But if it is 302, two option, death or life, court has no discretion. Had it been 304, court would have. How many years in custody?
he is in custody since 2019.
19. How old is he?
Now he is 62.
58 in 2022. 62. Absolutely no. I thought that is alibi. Sanjay Thakran is alibi. I don't know. Yes, Miss Bhuya.
Lordship,
Anything?
Lordship, observation, Lordship has observed the
To
entire
Support the
material.
prosecution case.
Yes, my lord. That,
Apart from what I had said also.
Lordship, subsequent conduct, then the cruelty, then your Lordship.
Anything on subsequent conduct?
I have, my lord, but
Ah.
the,
Paid to you. I paid. I paid. I paid. Huh? Ah, they not know. They not know. Ah. It was 8.2 them. He put in next.
can this PW1 be taken as a risk as to witness, your Lordship?
You know. No. Done. They will do that. Box. As the US standard, he offers no expert. Which, if you feel that the person is not fulfilling for the qualification, that. Also, will be complete. To divide. But it was further. It was fully as time tested. It voted three judges. Hmm. That's it. He moved. Hmm. Good. Hmm. No, we hide. Available. There is another principle law. Is that it's fine. Either of us merge. First, next week, this, and the see. This view has been taken from. This is a specific given third history. In the prosecution, evidence, and interpret. That's shortly before the commission of judgment. Oh, where the house, almost normal. It had. Oh, this requirement does not require any. Forms. What's it? Oh, no? Hello. Anything on res this year?
Yes.
Two second, about reading. Yes, anything.
Lordship, I'll find out.
Evidence of consent. Evidence of- Section 6.
Yes. May I cite
Hmm,
one judgment or subsequent conduct?
hmm.
আপোনালোকৰ আছে নেকি সেইটো মেইলত ল'ব পাৰিব? Harendra Rai. Harendra Rai versus State of Bihar. 2023, 13 SCC 563. কৈছে নেকি মেইল কৰিছো?
It's surrender the police station. Alright. Matok.
There are 70 of the judgment. পাইছে নেকি বাই দাদা? অহা নাই? পাইছে? মনুপত্ৰ সৰু হ'ব কনভাৰ্ট কৰি। তাৰপিছত No, no. You cannot. No. Cannot be.
লোকৰ মনত থাকে আৰু। Oh. Good. Okay. Again. Radio. What is that? All right. Did you?
But, if I'm allowed to, I have just observed a dark area because one dark area is there.
Huh?
One dark area is there.
Dark area.
Yes.
Ah.
The PW1, the son says he was watching TV with others in a neighborhood. So everybody rushed to the spot when they were informed. And the PW, it is only the PW1, that is the son, who has seen his father being fled away.
Because he immediately rushed.
But
From PW 2 and 3, if you analyze, son rushed immediately. That is again natural contact. See, I have read all three.
Yes.
Day 2 came later.
that is
Once
also,
again, it is there.
and
they
during
have
cross
stayed.
also it has come.
See, Horen Sharma.
Yes.
See, Horen Sharma. Perhaps you have elicited Horen Sharma.
As such, Babul Gwala and others were watching TV at my residence. All went to the house of accused Gulab Gwala, where there was a hue and cry.
I
There are-
also, thereafter, I
are-
also went. So
Yes.
he did not come with
Or
PW1.
Babul Gwala, yes,
Then next you see 3.
yes.
What he said? He said, Babul Gwala ran to the house of his father.
Yes.
I also went there along with Horen Sharma. So Horen Sharma said, I came later. I have read it already. That is a most natural conduct. Son being told that his mother was hacked, he would rush. But these two will, Horen Sharma will wear his
Later.
clothes. He was in his house.
In fact, it has come in his cross-examination also, that Babul Gwala already reached the home.
You have elicited everything by cross-examination. What should not be asked had been asked. Right?
Cannot help.
Paise neki?
Yes, what paragraphs?
Recall.
No, no, paragraph.
Oh, para 70, 71.
Only 70 seconds, 0 paragraph.
Conductor upor.
Our naam to khali.
Harendra Rai versus State of Bihar.
Third, sorry, this. You are amicus?
Yes.
This criminal appeal from jail. Under section 383 TRPC is directed against a why 2 dates? Oh.
See.
Incorporated. Judgment dated
70,
31/2022
70.
and an order on sentence dated 4/11/2022 passed by the Court of Learned Sessions Judge Vishwanath Sarili, case 40. In Sessions case number 106/2019. Full stop. By the judgment and order on sentence, the accused appellant has been convicted for the offense of, what do you say, uxoricide? Find out, UXOROCIDE. Offense of uxoricide under section 302 Indian Penal Code. and he has been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, rigorous imprisonment for another period of 1 month. Full stop. UXORO,
RICID.
RI or
RICID.
RICEDE. CIDE, like suicide, like suicide. Close. The it was alleged in a first information report lodged before the officer in charge, Bihali Police Station, on 3/6/2019 or 30/6/2019 by one C. Babul Gwala, who is the son of the accused appellant and the deceased, as the informant, that at around 4 p.m. that day, his father, that is the accused appellant, hacked his mother to death by a bora dao. We didn't make it a kind of knife. Full stop. The informant, that's PW1, stated that the incident took place when he was not present in the house. Full stop. On receipt of the FIR, the officer in charge, Bihali Police Station, registered the same as Bihali Police Station case number 58/2019 under section 302, IPC, and entrusted two officers, Sri Nipen Soikia, Sub-Inspector of Police, and Sri Biman Gogoi, and Assistant Sub-Inspector of Police, within bracket PW7, to investigate the case. Full stop. The facts facts which have emerged from the record and not disputed by the defense go to indicate that the IO, within bracket PW7, go to indicate that the FIR was received at the police station at 4 p.m. on 3/6/2019. Huh? 36, I have 36. 36, 2019. And the IO, within bracket PW7, proceeded to the place of occurrence, that is the house of the accused and the deceased at around 4:30 p.m. and he arrived at the PO at 4:40 p.m. traveling a distance of 6/7 kilometers. Full stop. At the PO, there was already a gathering of persons. Full stop. The IO did not find any broken articles at the PO. Full stop. After questioning the witnesses for a period of 15 minutes, he slow down. Asked one Nilokanto Tosa, a daily within bracket PW6, a daily wage earner, to remove the wearing apparel of the deceased Gulapi Gwala. Oh, Gulap and Gulapi. Gulap and Gulapi. And the dao was also pink. Gulapi Gwala, whose dead body found inside the house where the accused and the deceased used to reside. As per the instruction, PW6, remove the wearing apparels from the body of the deceased and the IO PW7 seized the following wearing apparels via a seizure list, MR number 20/2019, EXT 3 at 5 p.m. Dash, page 15 out, 1 blood stained gamusa and 2 1 blood stained sari. The informant who was examined as PW1 and Barindra Guho was witness to the seizure. Barindra Guho and Montu Baraik, who were PW 4 and 5, were also witnesses to the seizure. Full stop. The IO then conducted the inquest at the PO itself. And prepared an inquest report within bracket EXT4. Full stop. A sketch map of the place of occurrence EXT5 was also prepared by the IO. After completing formalities at the PO, he proceeded to the police station. Full stop. In the meantime, Babul Gwala, the informant as PW1, Babul Gwala, comma, Sosin Rajbongsi, PW3, and Montu Barak, PW5, also proceeded to the police station. Full stop. In order to, oh no, full stop. The IO, PW7, reached the police station at around 6:05 p.m. Full stop. As soon as he reached the police station from the PO, the accused appeared at the police station. Full stop. The prosecution stated that the accused appeared at the police station with the articles with the objects seized from him. Seizure list, MR number 19/2019 at the police station in presence of PW1, PW3, and PW5. Full stop. The cross prosecution has further asserted that the accused had also subscribed his signature in EXT2 seizure list. Full stop. The objects seized by EXT2 seizure list were page 57, a Bora Dao 1, and 57, 2, a 44-inch long stick. Full stop. The postmortem examination on the dead body of the deceased was performed at postmortem performed at Bihali PHC Primary Health Center. মানে 24 Bihali Block Primary Health Center by Dr. Deepak Kumar Bishwasi, the Senior Medical and Health Officer, posted there on 1/7/2019. Post on 1/7/2019. Post. After performing autopsy, or to BW8 within bracket. After performing autopsy, the doctor PW8 recorded his findings and opinion in the postmortem examination report within bracket PEXT6, which he exhibited during the trial with his signatures therein as EXT61. Full stop. Para. After completing investigation into the case, Kamalayo submitted a charge sheet under section 173 to CRPC, provide charge sheet number 41/2019 on 31/8/2019. Finding a prima facie case established to proceed against the accused for committing the offense of murder under section 302 IPC. Full stop. Para. As after his appearance, after submission of the charge sheet, the court of Learned Judicial Magistrate First Class Vishwanath Sareli secured the appearance of the accused from jail custody on 7/12/2019, as after his appearance, after his surrender before the police station on 30/6/2019, as since after his appearance, he was in custody. Post op. As the copies were ready, the learned the court of ZMFC, Vishwanath Sareli, supplied the copies to the accused as per the provisions of 207 ARPC, stop, as the offense under section 302 IPC is exclusively triable by the Court of Session, the committal court, by an order dated 7/12/2019, committed the case records of PRC case number, PR case number 305/2019, arising out of so-and-so police station case number so-and-so to the Court of Sessions. to the Court of Additional Session Judge Vishwanath Sareli for trial after notifying the public prosecutors accordingly. Full stop. Production warrants were issued to the jail authorities to produce the accused before the Court of Additional Session Judge Vishwanath Sareli within bracket trial court on 21/10/2019. Full stop. Para. On receipt of the case records of PR case number so-and-so, the trial court registered the same as Sessions case number 106/2019. Full stop. The case after hearing the learned public prosecutor and the learned defense counsel, and after perusal of the materials brought on record, the trial court on 21/12/2019 framed a charge of murder, framed a charge under section 2302 IPC against the accused. Full stop. When the charge was read over and explained to the accused, he pleaded not guilty and claimed to be tried. Stop. Para. During the course of the trial, the prosecution side examined the prosecution side examined the following 9 persons as prosecution witnesses and exhibited the following 7 documents as documentary evidence and 4 objects as material exhibits. Page 55, and in order to bring home the charge against the accused appellant. After closure of evidence from the prosecution side, the accused was examined under section 313 CRPC to afford him opportunity to explain the incriminating circumstances appearing from the evidence of the prosecution witnesses. Full stop. The accused, in his reply, stated that the prosecution had foisted a false case upon him. Full stop. When the accused was asked whether he would reduce any evidence in his defense, declined to reduce. Decline. Full stop. After hearing the learned counsel for the party, and upon evaluation of evidence of materials on record, the trial court has delivered the impugned judgment and order of conviction and sentence against the accused, holding him guilty for usury side. Full stop. We have heard Mr. A. Dhor learned Michael Skiri for the accused appellant, and Ms. P. Bhuiyan learned senior counsel and additional public prosecutor, assisted by Ms. R.
Salwe.
R.
Salwe.
R. Salwe. learned counsel for the state, Mr. Para, Mr. Or learned amicus preparing for the accused appellant has submitted that the case is based on circumstantial evidence. And there were many gaps in the case of the prosecution. First, the child who had reported first about the incident to the informant SPW1 was not examined by the prosecution. First, and the same has created a gap in the chain of circumstances. First, as the prosecution had failed to establish all the circumstances by way of evidence, by way of reliable and cogent evidence, comma, the accused did not owe any explanation as an accused has the right to maintain silence. Full stop. We have submitted that suspicion, comma, howsoever grave, comma, cannot take the place of proof as the prosecution has failed to establish the case beyond reasonable doubt, comma, the accused appellant deserves the impugned judgment. An order of conviction and sentence is liable to be interfered. Ms. Vian Lanet, Senior Counsel Public Prosecutor, appearing for the state, has submitted that all the circumstances to have all the circumstances established by the prosecution point unerringly towards the guilt of the accused appellant. First of all, it was it has emerged that it was only on the date of the incident, comma, it was only the accused and the deceased who were in the house, and the dead body of the deceased was found inside the house. Full stop. Therefore, comma, the accused clearly owed an explanation, and his plea as regards falsity in the prosecution case was an additional link to complete the chain of circumstances. Full stop. Ms. Bhuya has further contended that the subsequent conduct of the accused appellant is relevant under Section 8, Section 6, and Section 8 of the Evidence Act. Full stop. It is also contended that non-examination of the children would not have any effect in the prosecution case. Full stop. With such submission, comma, the learned additional public prosecutor has supported the conviction and sentence passed against the accused. Full stop. We have given considerations to the rival submissions of the parties and have also gone through the evidence stroke materials available in the case records of Sessions case number 106 stroke 2009, in origin. Full stop. Para. It has emerged from the evidence on record that on the relevant date of the incident, that is on in the afternoon hours, on the relevant date of the incident, that is on 30/6/2019. Sorry, that has emerged from the evidence on record, that the dead body of the deceased was found lying inside the house where the accused and the deceased used to reside as husband and wife. Full stop. The informant as PW1 is the elder son of the accused and the deceased. Full stop. The accused and the deceased have another son, have another son, who is younger to the informant PW1. Full stop. In his testimony, PW1 stated that on the date of the incident, the younger son,
Page 9.
younger son, name, any name?
Inspector Chief.
Dulugwala.
Dulugwala was not
No. Younger son.
in the
Dulugwala.
house. Full stop. And the said fact was elicited by the defense during cross-examination of PW1. Full stop. Para. The three witnesses, PW1, PW2, and PW3, at around 4 p.m. on 30/6/2019, were watching television in the residence of PW2. Full stop. At that time, your two minor sons of PW1, EIZ, Novojit Gwala, AZ 9/10 years, and Swetrajit Gwala, AZ about 3/4 years, came running to the house of PW2 to inform their father that their grandmother had killed their grandfather had killed their. On receipt of such information, comma, PW1 rushed to the house where his father and mother used to reside. Full stop. The PW1 with his wife and 2 sons used to reside in a house which was in the backside and vicinity of the house of the accused and the deceased. Full stop. Para. The 2 witnesses, comma, PW2 and PW3, were watching television with PW1, followed suit sometime later to reach the place of occurrence, PO, that is the house of the accused and the deceased. Full stop. All the 3 prosecution witnesses, comma, PW1, 2, and 3 testified that they found the dead body of the deceased lying inside the house with injuries, injury is on her neck. Full stop. PW1, who was first to reach the PO, noticed that there was profuse bleeding from the neck, and he tried to stop the bleeding by holding his mother's neck. Full stop. But the bleeding did not stop. Full stop. As per his testimony, comma, his mother was alive, but as soon as he put her head on his lap, LAP, comma, he died. It will put neck and ear. Full stop. The time when PW2 and 3 arrived at the PO, there was persons from the neighboring locality, also started gathering. Full stop. Para. The testimony of PW1, 2, 3, and 3 regarding the injuries sustained by the deceased on her person stand corroborated by the findings of the autopsy doctor, comma, PW8, and the postmortem examination report, EXT5, wherein the following findings as regards the injuries sustained by the deceased were recorded. Page 25. Para. The PW 8 testified that all the wounds sustained by the deceased were antemortem in nature. Stop. As per the postmortem examination report, EXT 6, PW 6 performed the postmortem examination report, PW 8, at 12 noon on 1/7/2019, and he found that the date of the disease occurred within 28 hours. Full stop. He further opined that the death was due to cardiorespiratory failure as a result of the injuries sustained. Full stop. In cross-examination, it was elicited from him that there was no other injury except the injuries, aforestated injuries. Full stop. PW further stated during cross-examination that it was not possible to sustain the injuries, as sustained by the deceased, if a person falls on a staircase. Full stop. Para. There is no dispute to the fact that the deceased met a homicidal death. Full stop. That's a paranoid. And in view of such evidence on record, there is no dispute to the fact that the deceased met a homicidal death inside her own house. Full stop. Para. PW 1 also testified to the fact that after he rushed as he rushed towards the house of his parents, and as he was about to reach, he saw his father, that is the accused, running towards the paddy field, crossing Loguri River. Full stop. He stated that letting his father go, he went inside the house and saw that his mother was lying inside the house in an injured condition. As he was informed that his mother was killed, his conduct to go inside the house to his conduct to go inside the house to see his mother rather than to catch hold of his father, cannot be termed as a circumstance in favor of the defense. So, the that part of the testimony of PW1 was never questioned by the defense during his cross examination. Rather, it was elicited by the defense during cross examination of PW1 that PW1 saw the accused running away from his house. A suggestion was put to PW1 that the accused did not flee from his house, but to bring the cattle back. Such a suggestion runs, such a suggestion. It is there, page 10. The suggestion given by the defense, the such kind of suggestion given by the defense would clearly indicate that the accused came out of his house when his wife was inside the house in a seriously injured condition. এরকম এরকম প্যারা it has the subsequent conduct of the accused which is relevant, was brought out by PW1, PW3, PW5, and who is the IO? And PW7. Full stop. PW1, 3, and 5 stated that after the death of the deceased, they went to the police station. Full stop. The visit of the prosecution witnesses to the police station received corroboration from the testimony of the IOPW7 and the said fact was on full stop. When the IO further stated that when he reached the police station, after he reached the police station, after conducting procedural formalities at the PO, the accused appeared in the police station with a dao and a stick of betel nut tree in his hands, which were seized by seizure list EXT 2 in presence of PW1, PW3, and PW5. Full stop. This the appearance of the accused in the police station and the seizure of the dao and the stick in presence of by the IO PW7 in presence of PW1, 3, and 5 was not disputed by the defense by cross-examining any of them during the trial. Full stop. The above circumstances, the aforestated subsequent conduct of the accused is relevant under Section 6 and Section 8 of the Evidence Act. Full stop. The evidence on record on an analysis of the evidence on record, including the testimonies of এই ওপৰত যে injury আছিল, injury. It was kind of injury লিখিব। PW4, who was a post-occurrence witness, testified that when he went to the PO, he saw that the dead body of the deceased was lying on the floor inside the house with cut injuries around her neck. Injury. Full stop. The wearing apparels of the deceased, MAT EXT1 and MAT EXT2, were seized by the IO in his presence at the PO. Digamos, itu ya aku televisi paling But it has a different, yeah, the- Or he pull up the gauge. In a case, it is settled. It is a settled proposition that in a case based on circumstantial evidence, comma, the prosecution has to establish the facts, and the facts established should be consistent with the hypothesis of the guilt of the accused. And they should not be explainable on any other hypothesis. Full stop. The circumstances should also be of a conclusive nature and tendency. Full stop. In a case of circumstantial evidence, comma, the judgment remains essentially inferential. Full stop. Inferences are drawn from established facts, comma, as the circumstances lead to particular inferences. Full stop. The court must draw an inference with respect to whether the chain of circumstances is complete, comma, and when the circumstances therein are collectively considered, comma, the same must lead only to the irresistible conclusion that the accused alone is the perpetrator of the crime in question. Full stop. Para. Para. It is also a settled legal proposition that in a criminal trial, comma, the purpose of examining the accused person under section 313 is to meet the requirement of the principles of natural justice. Full stop. The accused may be asked to furnish some explanation as regards the incrementing circumstances associated with him, and the court must take note of such explanation. In a case of circumstantial evidence, the same is essential to decide whether or not the chain of circumstances is complete. Full stop. Para. The position that at the relevant time on the date of the incident, it was the accused and the deceased who were the husband and the wife who were present inside the house. Full stop. The law does not enjoin a duty on the prosecution to lead evidence of such character which is almost impossible to be laid or at any rate extremely difficult to be laid. Full stop. The duty of the prosecution is to lead such evidence which it is capable of leading, having regard to the facts and circumstances of the case. Full stop. When an offense like murder is committed in secrecy inside a house, the initial burden to establish the case would undoubtedly be upon the prosecution, but the nature and amount of evidence to be laid by it to establish the charge may not be of the same degree as is required in other cases of circumstantial evidence. Full stop. The burden would be of a comparatively lighter character. Full stop. When an accused is alleged to have committed the murder inside the premises of a private property, and the prosecution succeeds in leading evidence to show that either immediately before the commission of crime or at the time of the commission of the crime, the accused and the deceased were together there without any third person with them. And if the accused does not offer any explanation how the deceased received the fatal injuries, or offers an explanation which is found to be false, then it becomes a stronger circumstance to indicate that he is responsible for the crime. Full stop. Such obligation is cast in view of the rule of evidence embodied in Section 106 of the Evidence Act, for which there will be a corresponding burden on the accused as the only other person present within the four corners of the premises with the deceased, to give an explanation as to how the murder was committed. Full stop. In such position, the accused cannot get away by simply keeping quiet or offering no explanation on the supposed premise that the burden to prove the case resting on circumstantial evidence would always be on the prosecution in terms of the rule embodied in Section 101 of the Evidence Act. And there is no duty at all on an accused to offer any explanation. Within bracket, Trimukh Maruti Kirkan versus State of Maharashtra, 2006, 10 is 681. We'll come back.
Referring the Kalu judgment already.
Okay,
addition
I've
given.
seen that. Judgment of 52, two more question. Three. The following passages, quoted in the three-judge decision in Devanandan Mishra versus the state of Bihar, AIR 1955. SC A01, para 53. Para 54. Para 50. Para 16, Kalu. Para. When the accused was asked during his examination under section 313 CRPC to provide 316 1B part 1B ho. You can. There was a question, no?
Yes.
When the accused was asked during his examination under section 3131B CRPC to provide his explanation, to the evidence appearing against him, the accused was found to be placed in position requiring him to provide an explanation how the disease sustained the injuries on his person. So, apart from other than stating that the witnesses had posted a false case against him, the accused did not offer any explanation as regards the implementing circumstances put to him as emerged from the testimony of the prosecution witnesses. Stop. During the course of the trial, the defense did not take any plea in the nature of alibi, even by way of suggestion, that the accused at the relevant time was not in his house. Full stop. Full stop. Or actually. Oh, proper. The PW1, PW1 further stated that his father, Aida accused, and his mother, the deceased Aida mother, used to quarrel with each other occasionally. Full stop. PW1, being the elder son of the accused and the deceased, can certainly have such knowledge, and he was not confronted with regard to such evidence by the defense when he was cross-examined. Full stop. The quarrels which the accused used to enter into with the deceased occasionally is a fact which can be taken as a circumstance to draw inference as regards involvement of the accused in the process of analyzing the circumstance in the chain of circumstances. Full stop. Along with the circumstances established by the prosecution to the prosecution witnesses, comma, which in our considered view are satisfactorily made out to point towards the accused as the probable assailant, comma, with reasonable definiteness and in proximity to the date of the in proximity to the event of death, in proximity to the event of homicidal death of the deceased, as regards time and situation, with him not offering any explanation as regards the injuries sustained by the disease inside his own house is a strong incriminating circumstance and an additional link to complete the chain of circumstances to reach a conclusion that it was only the accused. It was the accused only who was the perpetrator of the crime of uxoricide. Full stop. Para, in the light of the discussion made above, and for the reasons assigned therein, comma, we do not find any ground, comma, not to speak of any good and sufficient ground, comma, to disagree with the finding of guilt reached by the learned trial court. Stop. Hmm? See, no? Okay. Okay. As it has already been found that the prosecution has been able to establish all the possible circumstances to make the scene complete, comma, we find the instant criminal appeal is unmerited, and the same is liable to be rejected, full stop. Therefore, comma, affirming the judgment and order. When the order on sentence passed by the trial court, comma, the instant criminal appeal stands dismissed. Full stop. Recommendation দিব লাগিব চাগে ন? Compensation দিব লাগিব ন? Compensation লাগিবতো। পাচ্ছে মানে এটা প্রত্যেকে। Okay. We reiterate the direction here at 61. Here, this say. And 62. A or appreciation and remuneration. Trial court record is sent back.
Sometimes it becomes difficult to improve case in an appeal.
Yes, yes.
Like this.
Like
Cross-examination is weak.
that part was weak.
Perhaps legal aid counsel.
Obliged.
মাথা নামাৰে ন? Oh, 1 minute. 1 minute. হৰেন্দ্ৰ ৰায় কি আছিল কিবা আছে নেকি? Oh, section 8 যে কৈছিলো ন? কোনটো পেৰা ক'লে? 70. It says. Select 56. Section 56. Oh, আৰু এটা record. In the facts and circumstances obtained the case, comma, as discussed above, comma, the point urged by the learned amicus curiae regarding non-examination of the children
Childhood.
is found to have not affected the case of the prosecution in any substantive manner. আৰু কিবা পইণ্ট আছিল নেকি? Yes, Mr. Das, S. Das. Yes, yes, yes. Itu কি? PPDS আসবে। কোনটোৰ ওপৰত?
In this case, my lord, I am relying upon the judgment passed by our honorable High Court regarding
ডক্টৰ তুমি কি এইটো ডক্টৰৰ ৰেল বেছি আপোনাৰ পাই যাব এইটো আপোনাৰ পাই যাব
Third matter, item 11.
মুখ সিগনেচার না Yes, anything?
May please your lordship. In this appeal, my lord,
Huh?
I am relying upon the judgment passed by our honorable High Court regarding delay in filing the FIR, regarding delay in filing the FIR. Lordship,
এই মনু 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 শর্মাটো ওলাই প্যারাগ্রাফটো কেনা হেৰি কৰিব লাগিব ন এখন বনাই থৈছিলো মই নিজক
regarding unexplained delay in filing the FIR, which creates a doubt and which is fatal to the prosecution, and the FIR has no probative value.
Property value.
Your lordship kindly see
I'll see, just a minute.
there are 6, my lord.
We'll see, just a minute, sir. Which paragraph?
Paragraph 6, my lord. Paragraph 6 and 12, my lord.
Para. No. Other paragraph. Ah. Ah. Mr. Das has further urged that there was delay in lodging and registering
This is on 27th of June, my lord.
the affair
Incident also
As
took place on 25th of
of
June.
in respect of the incident occurred on 25/6/2017. The affair was registered only on 27/6/2017. So in support of his, he has relied upon a decision of a division bench of this court in Bull, Bull, Qri, Puri versus State of Assam, 2014, in bracket DLT 25. A part has already been dictated. The factual part has been dictated to an extent. IO, PW, Para 20. The IO, who testified as PW7, stated that before the FIR was lodged in Kalapani outpost, he had taken up the case for investigation on the basis of GD entry number 365 dated 25/6/2017. Full stop. The FIR was lodged subsequently by Aizal Haq PW2 on written FIR on 26/6/2017. Full stop. He registered the FIR in the general diary by general DD entry number 380 dated 26/6/2017 at about 3:30 p.m. And the case was thereafter registered by as Mankasar Police Station case number 506/2017. Full stop. The manner in which the investigation was carried out by the IO has already been alluded here in above. Full stop. The IO exhibited extract copy of GD entry number 365 dated 25/6/2017, the inquest report EXT4, the FIR EXT5, and the charge sheet EXT6, along with his signatures therein. Full stop. He further stated that he seized one dao, one knife blade. He seized the articles to objects from the house of the accused after charges carried out in the house of the accused on 25/6/2017 in reference to General Diary entry number 365 dated 25/6/2007. Full stop. Subpara of 24.1. In cross-examination, PW7 stated that he received the Ajar on 26/6/2017 as in charge Kalapani outpost. And after entering the details in General Diary, the FIR was forwarded to the officer in charge, Mankasar Police Station for registration. Full stop. The officer in charge, Mankasa Police Station, registered the case at 9:30 a.m. on 27/6/2017. Full stop. The IO stated that he recorded the statements of the witnesses prior to filing of the formal FIR and prepared the sketch map of the PO. After reaching the PO. Full stop. The IO, the defense sought to confront the IO by to the previous statements made by the prosecution witnesses. Without marking without bringing the specific parts of their respective statements to the notice of those prosecution witnesses at the time when they were examined in order to bring contradiction. And as such, in view of such failure on the part of the defense to bring in any contradiction in the manner required, a discussion on the said aspect is not necessary. Full stop. IO had the 807 stated that he did not send. Huh? Already. Even being spoon to or but it is intended to neither right, is it? People all those it which but the another contradiction but you must believe that way do such a place doesn't believe yes double I think the choice like but he did not send the DAO for examination to the FSL to find out whether there was any human blood stains or not. Full stop. Hold. PW7. DW1. Para 25. DW1 Hamida Bibi is the wife of the accused. Full stop. In her testimony in chief, DW1 stated that on the date of the incident, occurred 5 years earlier, the accused was returning home with his hand cart from market. Full stop. He saw that altercation was going on between the deceased and some Bangladeshi nationals. Full stop. He saw that Bangladeshi nationals were severely assaulting the deceased. Full stop. Then, her husband gave water to the deceased, Mojidur Rahman. Full stop. Bangladeshi nationals took away the cattle head from the deceased. Full stop. No one was present at that time. And her husband was not involved in the incident. Full stop. DW1 stated that there was no one present when the disease was assaulted. Full stop. Half para. In cross-examination, DW1 stated that Bangladesh border was 40-50 kilometers away from the PO at Fetamari village. Full stop. In the border, there was fencing. Full stop. So it was difficult to cross the border as BSF was in patrol, in duty there. Full stop. DW1 stated that the incident occurred on a government road near her house. And she did not know the Bangladeshi persons, nationals, with whom the family of the deceased used to trade in cows. Full stop. DW1 admitted that her statement was not recorded previously, and she had deposed falsely. Full stop. Para. DW2 is the accused himself, who testified to the fact that the incident occurred at 6 p.m. on the date of the incident. So on that day, he returned home with his handcart at around 5-6 p.m. Full stop. The deceased and Aijal Hawk. The deceased and the informant as PW2, Aijal Hawk, who were his relations, were involved in selling of cows, etc. to Bangladesh. On the date of the incident, 6-7 Bangladeshi nationals assaulted the deceased. Full stop. After on hearing about altercation, he went to the PO and saw that the disease Mojibur Rahman niki silo, was killed already, was already killed. Full stop. He further stated that the informant PW1 who was opposed to his marriage, which was solemnized prior to 2011, and prevented his wife from continuing the conjugal life. Full stop. DW2 further stated that a case was lodged in that connection, and in that case, he was arrested and in custody for 3 months. And later on, he was acquitted. So DW2 had, however, did not furnish any details as regards the alleged, as regards any case allegedly lodged by the informant PW. Full stop. PW2 further mentioned that he had 6 children, with the eldest being aged about 18 years. He denied to have committed the murder of the deceased and stated that after the incident, he was stabbed by all the witnesses of this case, for which he had lodged an FIR, and the case was being investigated. Subpara. In cross-examination, PW2 stated that he cannot go towards cannot enter into Bangladesh, even if he wished, as passport, visa, etc. were required to go to Bangladesh from India. And and he could not afford such kind of document. First of all, he further stated that he cannot identify anyone from Bangladesh. Full stop. He stated that he did not see injury on Mojidur Rahman, on the deceased. Mojidur Rahman. Full stop. It is, he denied that he kept 5 cattle belonging to the deceased tied inside his paddy field after they destroyed his paddy field. Full stop. Next para. DW 3. Mojibur, Mojibur Rahman. Was a boatman by profession, occupation, post. Deposing on the incident, DW3 stated that on the date of the incident, he hearing hue and cry, went to the PO and saw the dead body of the deceased. Full stop. He saw that the accused was giving water to Mojidur, and he was told by the accused that Bangladeshi people had assaulted the disease. Full stop. DW3 further stated that they chased those Bangladeshi nationals but they could not catch them. He will be inspired. He proceeded further. They had, however, recovered 8 cattle heads from the Bangladeshi national and handed over the cattle heads to Mankasar police station. Full stop. Stop. During cross-examination, DW3 stated that when he went to the PO, he did not see anything except the dead body and the accused with water. So it was the accused who told him that Bangladeshi nationals killed the deceased. So, police did not record his statement. Stop. DW3 stated that no one can go to enter into Bangladesh without proper documents like visa, etc. And moreover, there was border fencing and BSF personnel patrolling the border. Posto. He claimed ignorance about the event of cattle belonging to the disease entering into the paddy field of the accused. Para. DW4. Ilyas Rahman. stated that in the evening hours on the date of the incident, he saw the dead body of the deceased lying on a road. So, but he did not go near the dead body. But he saw the accused giving water to the deceased. So, he later on heard that Bangladeshi nationals who dealt in cow, etc., in breeding of cows, etc., had caused the incident. During during cross-examination, DW4 stated that no one could cross the border as there was border fencing and patrolling of PSF person. Full stop. He did not see any incident. Full stop. Well, as it has emerged from the discussion above that when the prosecution witnesses PW1, PW2, 3, 4, and 5 were examined. 4 were examined. 4 were examined. They were given suggestion that the deceased and the informant were involved in trading of cows with persons from Bangladesh. Full stop. But, they were not given any suggestion that in the incident of assault leading to the death of the deceased, there was involvement of persons of Bangladeshi origin. Full stop. Initially, when the accused was asked during his examination under Section 313 CRPC, he declined to adduce evidence in his support. Full stop. During his examination under Section 313 CRPC, the accused claimed falsity in the prosecution case, and he never whispered about involvement of persons from Bangladesh in the homicidal death of the deceased. Full stop. It was after declination, after his refusal to adduce evidence at a stage of 313 CRBC, the accused made a prayer before the trial court to examine himself and other witnesses in his support. Full stop. After the prayer was allowed, the defense witnesses, DW1 to DW4 were examined, wherein, for the first time, the defense witnesses projected that in the incident of assault which led to the murder of the deceased, there was involvement of persons of Bangladesh origin. But, DW1 and DW2 deposed that they did not know the assailants. Full stop. But DW3 deposing at the request of DW1 proceeded to say that not only he along with DW2 chased the assailants of Bangladesh origin, but also took cattle heads, also recovered cattle heads from them, to deposit it to the police station. Full stop. DW2 also deposed that it was to settle scores relating to, in connection with his marriage, which was solemnized prior to 2011, the PW2 hoisted the false case against him. Full stop. Para. DW2 himself stated that after solemnization of his marriage prior to 2011, he had 6 children with his wife, DW1. Full stop. Lodgement of a institution of a false case at the allegation of institution of a false case after birth of 6 children. Six children from the marriage is a story which cannot be comprehended. Full stop. When in the absence of, in the absence of any whisper, as regards involvement of persons of Bangladesh origin in the incident of assault leading to homicidal death of the deceased. In the absence of during thorough cross-examination of the prosecution witnesses, even by way of suggestion, and maintaining silence during on this aspect during his examination under 313 CRPC, it is clear that the stories sought to be projected by the accused by way of through the defense witnesses were clearly afterthoughts and unconvincing. Full stop. For acceptance. Full stop. Para. Next para. The learned counsel appearing for the accused has sought to contend that the death of the disease was not murder, but culpable homicide not amounting to murder. First, para. From the testimony of from the medical evidence in the form of testimony of the autopsy doctor, PW6, and the post-mortem examination report, EXT2, it has clearly emerged that the deceased had sustained a cut injury over neck exposing trachea. Full stop. The muscles, vessels, nerves were cut throughout. Full stop. There was another cut injury over the back of the neck, extending from angle of mandible, is 19 on left to angle of mandible on right side. Full stop. The muscles, vessels, and nerves were cut, exposing the spinal cord. Full stop. There was one further cut injury over the lower end of left arm of the size 2 inches into 1 inches. Full stop. The autopsy doctor opined that all the injuries were ante-mortem in nature, and the defense declined to cross-examine the autopsy doctor. The opinion regarding cause of death due to shock and hemorrhage as a result of the cut injury of her neck sustained by the deceased remained unchallenged by the defense. In any manner whatsoever at any point of time. Full stop. Para. On evaluation of the entire evidence, including the testimonies of the prosecution of para. The evidence of the prosecution witnesses PW 1, 2, 3, and 4 was categorical on the point that all of them had witnessed the assaults made upon the deceased by the accused with a dowel. Full stop. And as a result of such assaults, they witnessed that the deceased died instantaneously on the spot. Full stop. The presence of সহজা নেই ঝালে হয়ে গিয়ে ঠিক আছে বলবে পরে বলবো। এটা it has emerged that the house of PW1 was near to the PO. Full stop. That P1 arrived at the PO after PW2 finds corroboration from the testimony of PW2. Full stop. Their testimonies are oh, 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 the testimonies from their testimonies no, no, yeah. From their testimony, from the testimony of PW 1 to 4, 1 to 3, 4, comma. It has emerged that they are the ones among the persons. They were the first ones among the persons who rushed and proceeded to the PO. So, though itu tadi বেলেগ এটা আছে। The the defense had elicited from though PW though PW2 though PW3 though PW3 was not from the same village, comma, he in his testimony had explained the region of his presence near the place of occurrence at the relevant time. Full stop. Similarly, comma, PW4 had explained, had mentioned how he reached the place of PO after hearing hue and cry while working in his paddy field. Full stop. সহজা এটা পাই ৰাখিব সহজা বুলি লিখি মানে সিহঁতৰ প্ৰেজেন্ট the place of hope. The defense had failed. The defense had failed to discredit the testimony of the eyewitnesses as PW1, PW2, PW3, and PW in any manner whatsoever to raise any doubt regarding their presence at the PO and their witnessing the assaults made upon the disease by the accused with a dao. Recovery was in. Recovery was in. Dao was exhibited.
Yes,
Where is the seizure list?
seizure list. Page 83.
Izalis 83 madam. I was not sent for chemical test madam.
Ah. It was provide seizure list. EXT3. Page 83, EXT. Right? EXT1. A dao, one dao, one knife, one iron rod, and one bamboo stick, as described above, were seized from the house of the accused and in presence of PW five. Full stop. PW5 exhibited the seizure list. Full stop. Oh. E3 in presence of PW3 and PW4. Full stop. PW3 exhibited the dao, a small dao, one small dao, one big dao, and one iron rod as MAT EXT1, MAT EXT2, and MAT EXT3. It has been contended that on behalf of the accused that the seized, the allegedly seized, the allegedly seized weapon of assault was not sent for forensic examination, and it is a fact admitted by the full stop, the IO had also admitted that the alleged weapon of assault, the Dow was not sent to the FSL for examination. Full stop. Such fact of not sending the alleged weapon of assault was fatal to the prosecution case. তার আগরটা লিখে, তার আগর পেরাটো। In assessing the value of the evidence of the eyewitnesses, two principal considerations are, as observed by the Honorable Supreme Court in Sohoja Elias Sahajan Ismail Mohammad Sheikh versus State of Maharashtra, 2022-12 SCR, whether in the facts, in the circumstances of the case, it is possible to believe, page para 20 in Sohoja, it is possible to believe their presence at the scene of occurrence or in such situation as would make it possible for them to witness the facts deposed by them, and secondly, whether there is anything inherently improbable or unreliable in their evidence. In respect of both these considerations, the circumstances either elicited from those witnesses themselves or established by other evidence tending to improbabilize their presence or discredit the veracity of their statements, will have a bearing upon the value which a court would attach to their evidence. Full stop. When the testimony of the 4 eyewitnesses, Pedal 1, 2, 3, 4, are examined along with the other evidence, it is evidently clear that the defense had failed to discredit their testimony as regards their presence at the PO at a time of assault remained consistent. Full stop. This court has found there is nothing to disbelieve the presence of these eyewitnesses at the PO at the relevant point of time, and has found that their testimony are consistent and in corroboration to each other. Just Richard. Para 33. 34. 35. 36 only. The learned counsel for the appellant has also raised a plea to the effect that there was an element of provocation from the deceased, and it was in response to such provocation, the accused had reacted, and the provocation was sudden and grave. Full stop. The prosecution case is that catlets belonging to the deceased on the day of the incident, few cattle heads belonging to the deceased entered into the paddy field of the accused, and the accused kept the cattle tied inside his house premises. Full stop. It was having learned about the fact, having received the information that the cattle were kept tied by the accused, the disease was proceeding by the public road towards the house of the accused in order to get the cattle released. Full stop. It was at that point of time the accused waylaid and confronted the deceased on the public road, armed with dowels, and inflicted a number of blows on the person of the deceased, which, as per the PME report EXT so-and-so, were cut injuries, and one of them was a fatal one. Full stop. In such para 37, exception 1 to section 300, culpable is the offender while deprived of defense, and 38. Taking into the entire evidence on record, taking into consideration the aforementioned ingredients vis-a-vis the evidence of materials on record of the case in hand, we find that the plea of grave and sudden provocation is one which has to be discarded outrightly. Then 40. Huh? Similarly, the grounds urged as regards not sending the alleged weapon of assault, Dow for chemical examination is to be discarded. Full stop. On non-recovery of the weapon of assault or sorry, a weapon of assault is to be sent for chemical examination in order to establish a connect, more particularly when the weapon of assault was a bloodstained one, comma, the same with the alleged homicide of a person. Full stop. Sometimes it can be considered as a flaw in the investigation, full stop. But, comma, at the same time, comma, it is not an inflexible rule that the weapon of assault, the connection with the weapon of assault with the alleged homicidal death of a person is to be established. Full stop. It is also not a general and broad proposition of law that in case of non-recovery of weapon of assault, comma, the whole prosecution case gets weakened. There are 40. But 44. Argue. As a grievance. Fire. Or it will. The factors. Right. The factors enumerated in paragraph 23 of Gurmukh Singh Supra, comma, relied by Mr. Das. No, Gurmukh Singh Supra are required to be taken into consideration before awarding appropriate sentence to the accused. APC. Full stop. Those factors are required to be taken into consideration when an accused is to be sentenced under section for committing the offense under section 304 part 2 IPC. In the only punishment, the nature of punishment provided for committing the offense of murder under section 302 IPC is either death or death, comma, in case of rarest of rare cases, comma, or imprisonment for life. Full stop. We have already reached a conclusion that the offense committed by the accused herein is murder within the scope and ambit of Section 300 IPC. Full stop. As such, the definition, the decision in Gurmukh Singh Supra is not found applicable in the fact situation of obtaining fact situation. Full stop. মনু শৰ্মা কোনটোত আছিল? Para. It is true that it is a proposition that a delayed affair can bring adverse effect. An adverse effect to the prosecution case. Full stop. In Bulutari Supra, there should not be any delay in lodging the affair, in submitting the FIR to the magistrate, and it has to be communicated immediately. Full stop. In Buluturi Supra, the observation regarding delayed affair was made as the court had found that there was substantial delay of 16 hours in registering the FIR. Full stop. At the same time, full stop. In the case in hand, in the present case, it has emerged from record that the incident occurred at around 3:30 p.m. stroke 4 p.m. on 25/6/2017. And on telephonic information, ZD entry number 365 was entered into the general diary of Kalapani outpost at 5 p.m. on 26/6/2017. Post of thereafter, on 26/6/2017, the written FIR was lost before the in-charge Kalapani outstation and the in-charge Kalapani outstation, registered the same by GD entry number 380 at 3:30 PM on 26/6/2017. While forwarding the FIR to the officer in charge, Mankasar Police Station for registering a case under proper sections of law, and the officer in charge, Mankasar Police Station, had, in turn, registered the FIR as Mankasar Police Station case number 506/2017 on 27/6/2017. Full stop. While forwarding the FIR, the IOPW 7. Took up the case of the investigation. I had mentioned that he had already taken up the investigation of the case himself. And full stop. It has emerged from the evidence on materials on record that after arrival at the PO at (5:45 PM) on 25/6/2017, he proceeded to take steps. He initiated the procedural formalities required to be taken for a person to have met homicidal death in the form of inquest proceedings, and forwarding of the dead body for post-mortem examination in reference to Kalapani Outpost, General GD entry number 365, dated 25/6/2017. Full stop. Such steps taken by the IO pursuant to GD entry number 365 no, it cannot be conceived that a police officer had to wait for a first information report fulfilling the conditions under section 154 CRPC before taking requisite procedural steps in case a person was found to have made suicidal death till receipt of a written FIR under section 154 ARP. Full stop. At the same time, full stop, it is also settled that and a telephonic information given by any individual to the police is not for the purpose of lodging a first information report, but rather to request the police to reach the place of occurrence. Full stop. The contention regarding delayed affair raised on behalf of the accused is found to have no substance. Full stop. Para. Last. Taking the entire facts and circumstances obtained in the case, taking the facts and circumstances obtaining the case in its entirety, as discussed above, for the reasons assigned herein, we are of the clear view that the case clearly falls under clause quote unquote thirdly of section 300 of the penal code, which is punishable under section 302 IPC. Full stop. There was abject failure on the part of the defense to bring in exception 1 to section 300. Full stop. Therefore, we find no ground, not to speak of good and sufficient ground to interfere with the conclusion recorded by the trial court for the charge of murder in the case in hand. Full stop. Resultantly, the criminal appeal is found to be bereft of any merit. Full stop. Consequently, affirming the judgment and order of conviction and sentence passed by the trial court in Sessions case number Old New Detail page 41, first paragraph. The appeal is dismissed. The records of the trial court, record of the trial court is to be sent back for court fee. Yes, no. Yes, no. In view of the judgment and order passed in the accompanying criminal appeal number so and so, the instant application is accordingly disposed. But on a reopening day only, not be possible for to complete. Others are not possible. Not possible, Mr. Decker.
My lord, I'm praying for another date, attempt 8 and
Which
9,
one?
my lord. Attempt 8 and 9, my lord. I'm for the 9, my lord. My friend is appearing for 8. My lord, can it be on 3rd of February, my lord? 1st of February.
No, not so near.
My lord, because my
Some
lord,
are. already many.
Then my lord, on 10th of February, my lord, kindly be, my lord. But because there is medical report, my lord, I'm 74 years old, my lord, I'm suffering from breathing problem, my lord. The appellant.
Both fixed it was, no? Sometime, few days later.
12th then, my lord, kindly, my lord, kindly.
You're so, one day,
Then finally, my lord, 17, kindly 17, my lord.
17.
Deeply obliged.
Okay, PK Deka, appellant in 9. Who is there in 8? Mr.
I'm TL Chaudhary.
P.A. Chaudhary.
TL Chaudhary.
T.A. Chaudhary. Learned counsel for the appellant in 8 and Mr. R.R. Kosik, learned additional public prosecutor for the respondent state. Anybody else? You were there? Okay. Are present as sought for and agreed to by the learned counsel for the parties. List the appeals on 17/2/2026.
Deeply obliged.
Yes, Mr. Photogig. Next item. Not possible. No. Criminal level cannot be disposed of within. Which one? You need any urgent date?
It will leftover, it will come automatically then my.
Ah,
The next
item 6 or 7?
6.
Okay, leftover. Yes, Mr. Biswas.
Yes, will.
Oh, both. Same boat. Okay. 7 and 10. Leftover. And furthermore, we could have proceeded, but this bench is only for today.
Yeah.
Next week is not there.